Welcome to Simplifying the Complicated. In each episode, we'll get together with other professionals and have fun talking about trust and estate matters. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Now here are the hosts of Simplifying the Complicated, Lori Bolander and Lauren Gallagher.
Hi, welcome. I'm Lori Bolander.
I'm Lauren Gallagher.
Welcome to Simplifying the Complicated, where we talk about simplifying things around trust and estates. Today, we're going to do something a little bit different. You might notice we do not have a guest here today. Normally we do, but today we thought we would simplify the complicated around what we do. Today, we're going to talk a little bit about estate planning, including why you need an estate plan, what estate planning is, and how you get started on your own estate plan. There's a lot of different elements to estate plan and different reasons why you would do it. So we're going to kind of dive into that. And one of the big reasons people do estate planning is to avoid probate. And a lot of people say that they understand that they don't want to go to probate, but they don't really understand what it really is. At least that's in my experience. I don't know if that's the same with you or not, but they're like, yeah, I know, I just don't want to go. And that's true. And what it is it's really just the court procedure of taking assets out of your name when you die. And we'll kind of dive in a little bit into what probate is. A lot of people do have to go through probate because they have a relative or friend who has died and did not do estate planning or did not do it properly. And so they end up in the whole court process of probate. So a probate essentially has to be initiated by somebody you leave behind to take all your assets out of your name. And the process or the procedure was implemented to ensure that whoever's taking your property are the rightful people to be taking it. And so if you have a will, it will be submitted to probate. And the court will follow that will unless it's challenged, which is another reason to avoid probate, because these things all get put on, put out on display, and everybody's invited to come say their piece in court. But if you have a will, you can name your executor and you can say how your estate's going to be distributed, and it'll be followed. But if you don't have any of that, then there's a statutory scheme for who has priority to be appointed to administer your estate. And generally it's like, people you would normally think of, your spouse, your children, your parents. And there's a whole list of people in the order that they have priority to be appointed in. And then somebody is appointed in your estate. And what do we do from there, Lauren? Because that's the next step, right?
Yes. So from there, it's a long process. It's at least a year process. Somebody is, like Lori said, is appointed as the executor administrator of your estate. There's a creditor period. There's notice requirements. Everything moves at a snail's pace. We don't always get to set the timeline. Some of it's set by statute. Some of it's set by how backlogged the court is. So even to get your executor or administrator appointed could take several months. There's a movement at our local courts to expedite that, but still, even with an expedited process, it still takes 2 months. And 2 months once your petition is filed. So even to get the petition filed, sometimes it takes quite a while to gather the information, to determine if there is a will or no will, to figure out who the person is that should be and is willing to petition the court. So oftentimes
and bondable, because if you don't have a will that weighs bond, your administrator has to be bonded in the amount of what we think the assets are in the estate. And right. Also another thing that can take a long time is finding all the heirs. If you didn't die with like 2 kids, you may have lots of heirs out there. I've had I had one with 127 heirs. She had no children. She only had siblings, of which she had 9, and a lot of them are deceased. So, those are things that can back up even getting the petition on calendar.
Right. So all those things, so many moving parts, but then while that's all happening, maybe there's a mortgage that has to be paid or property taxes due, HOAs, other bills. We're not so concerned with, unsecured credit card bills. Those are not critical. But if a mortgage isn't paid in 3 or 4 or 5 months, things could really get dicey. And again, we don't have a lot of control over that. Certain circumstances we can go ex parte, but that in and of itself is a very labor intensive process and not always successful. So anyways, this is not designed to scare people, but it's just designed to inform people that if you're thinking it's okay to go through probate, it's really not, you're not doing anybody a favor.
Yeah,
You
and
might be
if you
but
have somebody, just to interject on like paying the bills, like the mortgage in the meantime, the other problem is, your sister might say, "Oh, I'll pay the mortgage until I get appointed." Well, and then she can usually access some estate funds and pay that. But she's not going to get reimbursed until the probate closes unless you go back to court for something else, and we can ask for reimbursement then. But it's most efficient to ask at the end to avoid dragging it out even more.
Yeah. And, we have some beneficiaries, some heirs in a probate that say, can I get a preliminary distribution? That is really not a standard thing. That is, you get your distribution at the end of the probate, year and a half later. Just like us, we don't get paid until the very end. There is a misconception that if things go to probate, your estate goes to the state. That is a misconception. That is not accurate.
I hear that all the time.
I have never once seen somebody's estate go to the state. The only way that would happen is if somebody died without any estate planning documents, no trust, no will, saying who they wanted their estate to go to, and that decedent had nobody surviving them, no next of kin, and I mean nobody.
No third, fourth, fifth cousins.
Right.
We have a duty to track that down, and people always say, "Well, they have no family."
Yeah,
I will tell you that there's usually family out there.
Yeah. And now with 23andMe and genealogy, we can find a lot of people on your tree you may never have known about. So that's just want to dispel that. That is not accurate. But the state is involved in the sense that the courts are governing the entire administration and dictating timelines and fees. So the fees, let's talk about the fees. The fees are very, very high in relation to what a typical trust administration would cost. Of course, in trust administrations, if there's, complicated factors or litigation, the fees will maybe exceed a statutory fee. But in probate, they're set by the value of the estate. And when I say value, I mean the gross value, not the net value, which is kind of interesting because you might have $1 million home with a $900,000 mortgage, meaning you only have $100,000 of equity, but the fees are based on the whole gross value. So, another real motivating factor and if the house is really the only asset, the only way to pay the fees is to sell the property, and maybe the family member doesn't want to sell, but they have no choice because they have to pull money out of their own pocket to pay those fees. So another great reason to try to avoid probate if possible. Everything is smoother, faster, cheaper, more efficient when you have a trust and there's a trust administration.
Absolutely. Fully agree with that, which is one of the reasons we do so many estate plans. And the probate fees are, like Lauren said, they're set by statute. And the executor, your administrator, and the attorney get the exact same fee. And now sometimes your family member may waive the fee, but usually most of the time they're taking the fee, unless they're like the sole heir. And then it's like, that doesn't make any sense. But
yeah, it's a lot of work. It's a lot of work for them.
Yes, absolutely. It is a lot of work. And, we do a lot of or almost all of the court filings, but the client has to do all the work to get us that information. What are the values of the accounts and who are the people and all that. So the statutory fee is 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and then what is it? 1% of the next 2.5 million. And I think past that, it's court's discretion. So that adds up real quickly to, most probate fees are going to be a minimum of around 10 grand and can go up to 50, 60 plus, So, and that's
easily.
Yeah, very easily. And then it's double that,
Mhm.
So yeah, it can add up real quickly. So that's a huge reason that people come in and do estate planning. Sometimes they have just gone through a probate with a family member, or have kind of seen one from a distance from a family member or a friend and been like, oh my gosh, I had no idea this was going to be like this. And we need to make sure that that doesn't happen to our family. So, how do you avoid a probate? Well, probate's the process of taking assets out of your name when you die. So, your goal is to have all your major assets not in your name. And that's really what a trust does, is it takes your assets and puts them into this vehicle called a trust. And you then, once you execute the trust, own those assets as trustee of your trust. And what the trust says is, when I die, then this person is the trustee. So that person steps in, takes control of the trust and the assets, looks at what you said, where to distribute those, and steps in and does that. And that's why it's called a trust. You don't have the court overseeing this person doing everything and saying, on this date, you have to file an inventory of what the assets are. And on this date, you have to do this. And on this date, you have to do this. So you are trusting that person, and you have to have a lot of trust in that person to administer this estate for you. And there's a lot of considerations when you're choosing that person as well. I know, Lauren, we talk about this a lot. We talk about this with every client. Do we want your family member to be the trustee? And often the answer is no. And sometimes it's not initially no. Sometimes it's, well, my son first and then my daughter, of course, And then it's like, then they tell me, oh, and he's a doctor in New York City and has 4 kids and is so busy and he's never has time to do anything. I'm like, so that doesn't really sound like a good person to be your trustee, because just like a probate is a lot of work, administering a trust is a lot of work. It's a job you are giving somebody to do, to be your trustee. And, it's not an honor. It's not a, it's not some big prize that they're winning. It is a job that they have to do. And it's usually a job they have never done before. So that's kind of where we come in. We get to come in and train the trustee on how to do the job. And also, we're training them for a job that they may never do again. So, and again, we help with a lot of, the documents and papers and, try to keep them on the straight and narrow. But there's a lot of reasons why you may not want a family member to do that job.
Yeah. Well, sometimes those family members don't get along with each other. So why would you put one family member who you're telling me doesn't get along with the other family in charge of that? That's just a recipe for a lot of problems and maybe for a disaster. And you can easily
avoid that by naming somebody else. And maybe
I have clients who say, well, the solution is maybe name the 2 of them together because they're going to be forced to work with each other.
No.
And yeah, the answer to that is absolutely not.
And in fact, one of our judges, who's now a justice at the appeals court, had said to us in a class that she was teaching us one time, or talking to us, said, please, please, please do not point co-trustees. So yes. I tell my clients that. I'm like, nope, the judge asked me not to do this. So
it's really hard for people to wrap their heads around. Even families whose 2 children get along beautifully, they still really don't want to wrap their head around the fact that it doesn't make sense, especially. And here we are telling them, hey, there's the doctor's son in New York with the 4 kids, and there's the daughter who's, off traveling the world.
Neither of them are really going to be available to be boots on the ground to do the administration. And
a lot of it can be done remotely, but there are certain things and certain tasks that really require presence here at the location of the administration. And if that person can't come when it's appropriate for the administration to be here, then that's probably not the right person to choose. And then we start looking at other family members and friends, professionals, corporations, lots of other options.
Yeah. And I've had more and more people say my kids do get along, and that's why I don't want to appoint either of them. I don't want them to get in a fight, because more, I think, as like kind of the baby boomers, that generation's starting to pass away, people are seeing this more and more closer to home. and they're like, oh my gosh, my neighbor and her sister, like it was this whole thing. They were best friends and now they don't talk, and they want to avoid that. And it absolutely does, because you have this third person in charge. They know what they're doing. And that's why I tell people too, like, yeah, they charge a fee, but A, your daughter or son could charge a fee. And B, they know what they're doing. So we have to do less. We don't have to train them in the job. We don't have to, hold their hand through every little step. They're off and running. They're like, okay, here's what we're going to do. Boom, boom, boom,
And I think family members tend to be on better behavior when there's somebody else that they are not related to being in charge. I think everybody just kind of keeps their good like best fit face forward. The daggers don't fly as much, and I think that's really important because families all have a dynamic. It doesn't matter which family. I have clients who come in and apologize for unloading their family drama on me, and I say, every family has drama. My family has drama. Every family has it. It's okay. But what we don't want to have happen is that dynamic to be amplified, any kind of potential negative thing that's going on in the family to be amplified by this event, by what is transpiring in an administration. So a lot of ways to avoid that is to not have the family members be the person who's administering the estate.
Yeah, absolutely. Another benefit of the trust and the estate plan in general, because another document we will talk about in a little bit is power of attorney for financial affairs. But the trust and that document together avoid a conservatorship of the estate. So if you get dementia and don't have capacity and can't pay your own bills, somebody has to step in and do that for you. If you don't have these documents in place, that goes to the court, right back to probate court, right? And the conservatorships, which I used to do, I still do them occasionally. But I always say that they're worse than a probate because, for one, you're alive, and they're more expensive than a probate, generally speaking, because for one, it really invites a lot of discord within the family because there's two kinds of conservatorships, estate and person, and the person is the health part of it, right? And so you get different family members vying over these roles and who's better. And because there's been a lot of abuse and conservatorships in the state of California and nationwide, the stack of paperwork you have to file to get appointed is like immense. And it's a huge hurdle because you're actually taking away people's constitutional rights. This is the only place in probate where there's a jury trial. Because you have to prove to the court that this person can't, beyond a reasonable doubt, that they don't have capacity. And that's not always an easy hurdle to get over. And they're appointed counsel. So there's another cost. Sometimes a guardian ad litem is appointed. That's another cost. So we can avoid all of that as well with this estate plan. And my point in saying that is that a lot of times people don't think about the fact that their trustee may be serving while they're alive. Which is yet another reason to possibly have a third party, because that can get real hairy when you've got maybe one sibling that's taking care of mom and taking them to the doctor, and another sibling that's in charge of the money. That invites more problems. It just can get real hairy. So sometimes just having a neutral third party that doesn't have any connection to anybody paying the bills and maybe not making the medical decisions, maybe that stays with the family, but at least the one that's kind of overseeing and making sure you're being cared for. But yeah, it's something that, like, when I bring it to my clients, like, well, if you're incapacitated, then this person's going to take over. And they're like, oh, well, in that case, that's a whole nother conversation. And sometimes it is.
Yeah. Yeah. And just another reason to avoid just kind of adding on to what you were saying, Lori, about a conservatorship, we were talking about the kind of the legal end and the cost end, but the personal end is your affairs are all there, public. They're talking about you as if you're not there because they're claiming you aren't, and maybe your capacity isn't there, but you are still alive, and it feels very invasive, and your privacy is invaded in many, many ways. I think if you ask any potential client who's sitting across the table from you, do you want that? Would you want that if you became incapacitated? And every single person's going to say, no way do I want that.
Yeah, absolutely
so just
not.
like you were saying, the planning is even more important for the potential scenario that you are no longer able to manage your own affairs, but you're still living versus you're gone. You've passed away. Yes, that is, you don't want to leave a mess for your family and your loved ones, but you are doing yourself a favor and your family and friends who are in your circle if you take care of the paperwork so that those things are addressed while you're still living. You've got all that paperwork available.
Yeah,
People have numbers to do all the things.
absolutely. And I've had cases, I mean, just talking about the cost of it, I've had cases that started in a conservatorship and then ended in a probate. And the cost around that was immense compared to what they could have paid for an estate plan. It's like, and usually we try to avoid a probate in a conservatorship doing a petition to set up a trust for them, but sometimes we can't because they pass away too quickly and we don't have time because the courts are backed up. So these are court proceedings that you pretty much can listen to this and say, wow, I want no part of that. I better set my estate plan up. There's another court proceeding that trusts help with as well. And it's one that people don't really think about at all because I don't think they even think it's a thing. But if you have minor children or minor grandchildren that will inherit or may inherit, if you do not have a trust specifying how those funds are going to go to them, a guardianship procedure has to be brought, and that is also in probate court. And those were, started in probate court because it's usually when somebody died and left a minor money, right? And because California's kind of been on the leading edge of all of this, and it's partially because of the entertainment industry here. Back long ago, I think in the mid 80s, early 80s, it was determined that if a minor was entitled to more than $5,000, the parent could not be the custodian of it. And that got started in the entertainment industry and kind of got brought over to the probate industry, where it's like, yeah, if it's over $5,000, like we got to have some fiduciary duties and some controls on this. But a guardianship's much like a conservatorship, where you have to be appointed to manage this person's money. The other thing about both those proceedings is that you have to account to the court usually every year, sometimes every other year, but that's an expensive process as well. That happens every single year until the conservatee dies or the minor turns 18. The other problem with the guardianship is that when the minor turns 18, they get that money. That's it. I've had clients beg me, like, what can we do to keep that from happening? I'm like, there's nothing we can do. All we can do is tell them to go to a financial planner and get a good lesson on managing finances and preserving, wealth for future and all that. But that's all we can do. So with your trust, you can actually set up these kind of like sub-trusts that hold this money for the minors. And essentially the trustee can pay for anything that they need, and you can tailor this. If you say, oh, I only want my, grandkids to get money for education, that's what it can say. But if it's your own children, you would want to make sure they have everything. So generally the standard is health, support, maintenance, and education, which, is pretty broad, does have a little bit more of a technical definition. But while they're holding it, they can pay for all of those things. And then the decision, in your trust becomes, okay, well, what age are we handing them that check for what's left? And people do that all kinds of different ways, at ages or split it up or whatever. But again, it's avoiding that guardianship procedure. And I have had cases where, there's had to be a probate and a guardianship. And, so it's like, avoid all of this with your, simple and relatively affordable estate plan. So I mentioned the power of attorney. That's another document that we established as part of the estate plan. And people are usually very confused about this document. I don't know why it is. I explain it, numerous times to my clients, and it never fails. However many years later, they come back in and say, we just really don't know what this one is for. And so in your trust, you're appointing your trustee to handle all of your trust assets. If you are incapacitated, there are going to be assets outside of your trust that the trustee will not have access to. So this power of attorney is there so that they can access your retirement funds, to take your required minimum distributions, to file your taxes as an individual, to, sell your car if you can't drive anymore. So things like that are outside the trust. Obviously, if you don't have a trust, that document's even more important, because then it would be everything. So it's an important document. Sometimes we never use it because you're alive and well, handling all your business, and then you die. But there are situations where I've had clients that have had incapacities that last 20 years. And had we not had a power of attorney, we would be in real trouble. We'd end up with some trust assets and a conservatorship. Now, ultimately, we can usually terminate that and get it over to the trust, but we can avoid all that with this power of attorney.
Yeah, and those powers of attorney are, important even just for spouses. You think, oh, well, I'm married, I have the same last name, we own property together. That is not necessarily enough. And, if your spouse is in an accident, ends up in the hospital, has some medical event, and is not, able to do something for themselves, even if it's just a limited period of time, you might need to use their power of attorney to deal with an insurance company if those are, they have insurance benefits, or to make a claim or file a lawsuit. Those kinds of things those powers aren't just given to you by virtue of being married or being related to somebody. You actually need a legal document, properly executed and filled in correctly to be able to act on that. So that comes as a shock to a lot of people. Like, really? I can't just do that for my spouse? No, you can't. You cannot do that for your spouse. You can't even do it for your young adult children. Right. And so here's another, we've talked about this before, that once your child becomes 18, you no longer have access to their medical records, which you're actually limited to that to some degree, even before they're 18. You have no right to handle or manage any of their financial affairs or get into their bank account. So I always recommend for clients who have
their newly 18-year-old child going off to college to have that child sign a new power of attorney, healthcare directive, and a HIPAA authorization. Even if they don't have anything really to their name,
it gives the parent some ability to handle things if there's a crisis, or to make a medical decision if that child's in a car accident away at school. So,
yeah. And I've heard stories that people have had that situation happen, or something happens on campus and the parents call and they're like, what is going on? And the school's like, I can't tell you anything. And they're like, I'm paying for this education. It's like, they're an adult, there's HIPAA laws in place. And so, it's really important. And important as part of your estate plan when you have a trust. So, and you're mentioning the healthcare directive and, these HIPAA waivers and whatnot. And that's an extremely important document as well. Usually between spouses, that's one that, they'll let you cross some lines, but if there's any big decisions to be made, you're going to need that document. And so this is where you can appoint somebody to make healthcare decisions for you if you cannot make them yourselves. And within that document, we can lay out some of your desires and decisions about end of life care and donating organs and, disposition of remains and things of that nature. And then it's got all these releases as to that person for your medical providers, so saying you can talk to this person, you can tell them anything that you would tell me, because like in a situation where somebody has dementia, the doctor can talk till they're blue in the face and the person is not really going to comprehend what's really going on, so they need to be talking to this third party that you've appointed.
Well, and those HIPAAs, like sometimes you need the test results or the file to be able to make the decision that you have the power to make. Right. So you don't want to run into
a step in as trustee, right?
Yeah, or step in as trustee. Another thing that is really interesting is if you do not have a healthcare directive, or you do not have something in writing that gives somebody the power to make your final wishes, you're deceased in this situation.
Somebody needs to order your death certificate. Somebody needs to arrange whatever it is, cremation or burial.
Without that power of attorney or healthcare directive, it requires all of the next of kin to make reach a consensus and all sign off on the paperwork, which in the few cases that I've come across has been, oh boy, not a pleasant situation.
I had one that almost went there recently, and I forget what I don't remember what statute governs that, but she was like, oh, under this statute, like we have to have this. And luckily, what happened was my client was appointed as trustee, but they didn't do it for this one. It was only the authorization for burial. There's a whole separate document. It was weird. But that person didn't hand it over to her. Luckily, we just got him to sign off on it. He's like, yeah, I'll sign it. So before it had to go down the line, which would have been a nightmare because her son is indisposed because of some elder abuse that took place. So
Okay.
yeah, fun.
Whole different story,
So,
different podcast. But
yeah, but no, it's serious. Like they can't, you can't authorize a cremation or a burial and then get the death certificate unless you have this document.
Yeah, it really, I've seen it delayed for weeks and weeks and weeks. Obviously not what the decedent would have wanted, usually not one of many family members wants, but either there's a disagreement or somebody can't be located, they're not cooperating, they want to be in charge, they don't want to be told what to do. So it is so awful when you think about that. But that power of attorney for healthcare, or healthcare directive, those are kind of interchangeable terms for the same thing, is so critical. Even if the document doesn't say what it is you want, I always encourage clients to say, hey, if you want to be cremated, and it's even if it's, or you want to be an organ donor, even though it's on your driver's license, put it in your healthcare directive. It's there. It's a document you sign. It's evidence of your wishes. But even if that is not in there, you've just chosen to leave that part blank, you have still appointed somebody to make those decisions for you. And that's the critical part.
The real kind of like icky part of all of that is, guess where you are while all of that's getting figured out? In a refrigerator. Yeah. It's really, I had one that took like a really long time, and I would just be going about my day and then think, oh my gosh, he's still in that refrigerator. It's just so horrible to think about. So don't do that to your family.
It's so easy to avoid. That's the beauty.
Yeah,
I mean,
exactly.
The whole point of this discussion is to point out the ways to make your life easier, to make your loved one's lives easier when the time comes for them to step in. And you can do that by just signing the appropriate documents. And we're talking trust, will, financial power of attorney, medical power of attorney or healthcare directive, that HIPAA authorization, and some other ancillary documents. Really, the whole purpose of it is to put your wishes in writing, to name appropriate people to act on your behalf when to take whatever action is necessary, and for them to produce that paperwork to say they have the power to do that.
And people get overwhelmed when thinking about this process. I mean, for one, you have to confront the fact that you're going to die, but we're all going to die. So there's that, so, and then thinking about incapacity or thinking about leaving your kid, dying, and you've got minor children. It's horrible things to think about. But if you can get past that, people also think that it's like all this paperwork and work and you have to gather all this information. It's really not as involved as people think. People are like, well, what do I have to send you bank statements? No, I don't need any of that. I need to know where you have accounts, what kind they are. I'm pulling the title to your house. I don't even need you to bring me anything. So it's a lot less involved than people think that it is. And I've been told, I think you have too, Lauren, that we make it easy. They're like, wow, you made that really easy. So, that's what we're here to do, is to help people get these plans in place, because we don't want to see, another probate and your family having to go through probate, and that's where a lot of fighting can happen, like I said before. So it's just a very simple way to do it. And then, of course, we always get the question of, why can't I just go online and do a trust? You know what? Mm-hmm. You can. Guess what? It's probably going to end up in our office and cost a lot more than we would have charged you to do it. Because those online mechanisms, they don't give you the full picture or the full information about how it's going to work. They're often unfunded, meaning no assets are actually in your trust. I had one where they, said, oh, we just did this quick before we went to Europe. Can we just look it over? Well, what their intent was to appoint their siblings to take care of the money for their minor children. But what they had done is give all the money to the siblings and disinherited their children. So that would have been a big problem. So, when you're doing these online things, you have to have some education around it, which we provide for people in the process. Everything we've said here today pretty much kind of goes into our estate planning meetings with people. And so you understand what you're doing, what you're appointing the person for, what they're going to be doing, why the document exists, what assets it covers. Most people forget it, 10 minutes after they sign their estate plan, and that's fine. At least during the process, they understood what we were doing and why it was happening.
And we're also here as the resource going forward. So you might have signed your estate plan in November 2023. You can contact us anytime to ask, hey, why did I do that? What does it say? Who do I have named? And that's a great thing to do, really, is
Or
for us.
was I supposed to put that brokerage account
Yeah.
into the trust? That's a
Yeah.
very important part of it too, is we're going to give you detailed instructions and documents to help you make sure all these major assets get into your trust. We take care of the real estate because that's very important. But there's other assets that can trigger probates too. So, and I don't think, do we even talk about the probate limits? But for bank accounts and personal property, if they total $184,500, you go to probate. For real estate, if the gross value is $61,500, which I don't know what wouldn't be in California, it goes to probate. So, those, you got to get those big assets into probate or into your trust so they don't go to probate. And we give you instructions on how to do that. And, I tell clients, if you go to the bank and they give you a form to fill out, just send it to me. I can do them in my sleep. I'll just send it back. Done. So that's an important part of it too. So, we're here to walk you through the process, make it easy, hopefully. But it's important to us that, people have this in place. I think as people that live in a community that feels very small anyway, here in Ocean Beach, we want this for our community members. We don't want to see siblings fighting and people in probate and losing the house and things like that. So,
yeah. So you need your own estate plan, but don't forget your aging family members, because that's a lot of the work that we do. Is we help either existing clients or adult children who say, gosh, my mom just fell and I'm worried. I think now we're in a different phase where I need to be more involved. Can I bring my mom in? Can you help us figure out what it is mom or dad needs to make their life better? And so that's a large part of our practice.
Which will make your life better, because if you have all the authority and all of the documents that you need, it'll be a lot easier.
Yep.
So yeah, absolutely.
Yeah.
Well, I think
I
think we kind of covered it all. So we hope you enjoyed our discussion today and learned something, and hopefully it simplified some estate planning for you a little bit. And if you want to hear more about estate planning or schedule an appointment to come in, you can find us at lawgbs.com. So thanks for joining today.
Thank you.
You've been tuning into Simplifying the Complicated with your hosts, Lori Bolander and Lauren Gallagher. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Thank you for your positive feedback, comments, questions, and for sharing this show with others.